Okay, so we are going to study about Dpsp. Dpsp is mentioned in part 4 of our constitution from article 36 to 51. Actually, Dpsp is mentioned from 38 to 51. 36 just tells the definition of state, and 37 just tells that Dpsps are fundamental to the governance of the country. So it's actually from 38 to 51. Now, from where did we take this Dpsp? We took it from Irish constitution. Irish had enacted their constitution in 1937. They took this directive principles from Spanish constitution. So this is how it goes. And then Dr. Ambedkar told that DPSPs are novel features, and the DPSPs combined with fundamental rights constitute the soul of the constitution. Granville Austin, he told that DPSP and fundamental rights describe the conscience of the constitution. Now, some of the features of DPSP. DPSPs are considered as constitutional instructions or ideals given to the state for formulating policies or laws. Now, I told that Article 36 is the definition of state. It is the same definition given in Article 12. Okay. Then another feature is it is an instrument of instruction given in Government of India Act 1935. What is this instrument of instruction? It was issued to Governor General and governors. Basically, they were executives. No, it was given to executives as directives. But here, DPSPs are instructions given to both executive and legislature. So they act like instrument of instructions, but both for executive and legislature. Then they embody the concept of welfare state. What is welfare state? Everything given in the preamble: justice, liberty, equality, fraternity. Basically, they established DPSP establishes social and economic democracy. Now, another feature of DPSP is they are non-justiciable and not legally enforceable. Article 37 says that DPSPs are fundamental to the governance. It is a duty of the state to implement DPSP. And another feature is they help the court examine the constitutional validity. For example, if any law is made giving effect to Article 39B or Article 39C, and if that law violates 14 and 19, then reasonably you can say that that law can be made valid. So that is like they help examine the constitutional validity as well, DPSP. Now the classification of DPSP. Now this classification is not done by the constitution, it is done by us. Now first classification is socialistic. Now these are the articles which are mentioned in socialistic. Let me go one by one. Article 38. What does Article 38 say? To promote welfare and minimize inequalities in status, income, facilities and opportunities. Now this article, this underlined portion, it was added by the 44th Constitutional Amendment Act 1978. Then, for example, how did this Article 38 got implemented? By Planning Commission, Niti Aayog. This is how it got manifested. Article 38. Then Article 39. Article 39 has 6 subclauses. First clause, subclause A, livelihood for all. How did we implement this? The National Rural Employment Guarantee in 2006 we launched to implement this subclause. Then subclause B, equitable distribution of resources. For this, what we did implemented land reforms. First Constitutional Amendment Act, then nationalization of commercial banks we did. Then subclause C, prevention of concentration of wealth. For this we did abolition of zamindars and abolition of privipers. So this B and C constitute economic justice. Then subclause D, equal pay to men and women. For this we enacted Equal Remuneration Act 1976. Then preservation of health and strength of workers and children. For this we made a primary healthcare center, hospitals to fight against malaria, leprosy, AIDS and many such diseases. Then subclause F is opportunity for healthy development of children. This underlined, so it was added by the 42nd Constitutional Amendment Act 1976. Then Article 39A. This provides equal justice and free legal aid to poor. For this, we made NALSA. NALSA is National Authority for Legal Services. National Legal Services Authority to aid the poor. This also was added by the 42nd Constitutional Amendment Act. Then Article 41 basically to secure the right to work, education, and public assistance in case of unemployment, old age, sickness, or disability. For this, we enacted Contractual Labor Regulation and Abolition Act 1970. Then Article 42 is Just and Human Conditions and Maternity Relief. For this, we enacted Bonded Labor Abolition Act and Maternity Benefit Act 1976. Article 43 secures living wage, decent standard of work, socio-cultural opportunities. For this, we enacted Minimum Wages Act, Khadi Village Industry Commission, Coir Board. Then Article 43A, participation of workers in the management of industries. This also was added by the 42nd Constitutional Amendment Act. Then we have also Industrial Disputes Act. How did this manifest? Industrial Disputes Act, Trade Union Act. This is how we implemented 43A. Then Article 47 to raise the level of nutrition and standard of living of people to improve the public health. For this, we implemented National Health Mission, Public Distribution Scheme, Integrated Child Development Scheme. Then some awareness campaigns for like polio and for AIDS. We have some awareness campaigns. Then Swachh Bharat Abhiyan. So all this we did for implementing socialistic Dpsps. Then Gandhian classification of Dpsps. Article 40 to organize village panchayats. Village panchayats nothing but unit of self-government. For this, what we did, we passed 73rd Constitutional Amendment Act to form panchayats. Then Article 43 promote cottage industry. For this, we made a National Small Industry Corporation and Handicraft Board, Silk Board. Then Article 43B talks about cooperative societies, voluntary formation of cooperative societies, autonomous functioning, democratic control, and professional management of cooperative societies. This was added by the 97th Constitutional Amendment Act 2011. Through this, we created AMUL. Then IFCO means Indian Farmer Fertilizer Corporation Limited. Then NABARD for finances to the cooperative societies. Then Ministry of Cooperation in 2021 it was made. Then Article 46. Article 46 talks about the promotion and protection of SC/STs and other weaker sections. For this, we made NCSC and NCST. And also the SC/ST Prevention of Atrocities Act 1989. Then Article 47 talks about prohibition of liquor and intoxicating drugs. For this, we passed the Cigarettes and Other Tobacco Products Act, excise duty on liquor. Then Article 48 talks about the prohibit slaughter of cows and draught cattle and improve their breed. For this, we have Rashtriya Gokul Mission, and Gujarat had passed Cow Protection Act for prevention of slaughter of cows, and the National Livestock Mission we also have launched. Then liberal intellectual classification. Article 44 talks about Uniform Civil Code. This has been implemented only in Goa right now. Goa Civil Code they have. And there is a case, Supreme Court case, Shah Banu case, in that the Muslim personal law was discriminatory. So Supreme Court called for Uniform Civil Code, but it was not implemented. Then Article 45, early childhood care and education until 6 years. So this is underlined, no? So it was amended by 86th Constitutional Amendment Act. This 86th, it also added Article 21A. Article 20A is basically right to education. From which years to which year? From 6 to 14. This Article 45 is from 0 to 6, whereas this 21 is from 6 to 14. Then through this article, we made a National Early Childhood Care Education Council, Integrated Child Development Scheme, Poshan is nothing but midday meal scheme. Then NEP 2020. In NEP we have 5 plus 3 plus 3 plus 4. What is this 5? From 0 to 5 years, foundational education will be given. So it is on the lines of this early childhood care and education. Then Article 48, Organization of Agriculture and Animal Husbandry. We enacted Prevention of Cruelty to Animals Act 1916. Then Green Revolution for Agriculture, HYV seeds. Then Article 48A, to protect and improve the environment and safeguard forest and wildlife. It's underlined, so it's 42nd added through by the 42nd Constitutional Amendment Act. And through this 48A article, we made Wildlife Protection Act, then Forest Conservation Act, Water Act, Air Act. Then Article 49, to protect monuments, places, objects of historic and artistic interest which are declared of national importance. For this, we passed the Ancient Historical Monument and Archaeological Sites and Remains Act 1951. Then Article 15 talks about separation of judiciary from executive. This is very easy to remember. 50 means Adha, no? So separation, Adha Karna. Judiciary from executive. CRPC in 1973. It was enacted to separate the judicial function of collector or tehsildar from executive function. It was basically taken away. This judicial function of the collector was taken away and put into the district magistrate, who would work under the state high court. Alright, then Article 51, to promote international peace and security. For this, India had adopted NAM, then Panchil. Then sanctions behind the Dpsp. Now some people have told this about Dpsp. Aladi Krishnaswamy Iyer, he told that you cannot take part for lightheartedly. Then B.R. Ambedkar told that government can hardly ignore Dpsp. If you ignore Dpsp, then government will be answerable to the electorate in the next coming up election. And Dpsps are non-justiciable and non-enforceable because country had financial restraints at that point of time. Why it was made non-justiciable? These are the reasons. Countries had financial constraints, and there was huge diversity and backwardness, and it was a newly born India. So if you start implementing these Dpsps, it would be crushed by its own burden. Then some criticisms. There is no legal force behind this Dpsp. K.T. Shah told that it is pious superfluities and compared them with a check on a bank payable only when bank resources permit it to. Pious means overly religious, excessively religious. Superfluities means not necessary. Okay, Naziruddin told that it is like some New Year resolution. You break that on 2nd January itself. And then T.T. Krishnamachari told that it is a veritable dustbin of sentiments. Then KCVR told that it is a manifesto of aims and aspirations, moral homily, nothing but moral lectures. He just told this. Then Sir Ivor Jennings told that it is just pious aspirations. Another criticism is they are illogically arranged. N. Srinivasan told that it combines science with sentiments, prejudice, so it's illogically arranged. Then Ivor Jennings told that no consistent philosophy is mentioned in the Dpsp. Then it is conservative in nature. Sir Ivor Jennings told that it is based on the 19th century political philosophy of England. Basically, these two people, Sidney Webb and Beatrice Webb, whatever work they had done, it is reflected in the pages of Dpsp. So it is very conservative in nature. Then Fabian socialism without socialism. What is Fabian socialism? Basically, if a country wants to move towards socialism, there are different ways. You can either move incrementally or you can move by revolution. Now, Fabian socialism tells that you don't want revolution. You can move incrementally. For example, first let the government nationalize all the industries. Then let the government give welfare program schemes to the people. Then maybe improve the standard of living. Then working conditions. Slowly we can go towards socialism, not through revolution. That is Fabian socialism. But they told that this is Fabian socialism without socialism. We were doing some incremental reforms, but we were not moving towards socialism. We are moving towards capitalism. This Fabian, no, he is named after a Roman guy called Fabius Maximus. Then constitutional conflict. K. Santanam told that it will create conflict between center and state, president, prime minister, governor, and CM. How center and state? Suppose center tells the state to implement Dpsp, and if the state doesn't comply to it, then center can dismiss the state government. Then in case of president and prime minister, suppose if the prime minister passes a bill, and if that bill is violating the Dpsp, then the president can reject it, saying that it is violating the fundamental governance of the country. Right? This is same case for governor, CM. Then utility. Some people have told that, like LM Singh, we have told that Dpsp is a life-giving provision, constitutes the stuff of the constitution and philosophy of social justice. And MC Chagla told that if the principles are carried out, then India will become heaven on earth. Basically, we'll have welfare state plus democracy. Then B.R. Ambedkar told that Dpsps are of great value, and the goal of our country is economic democracy as distinguished to political democracy. Then Granville Austin told that Dpsps are aimed at achieving goals of social revolution. The goals of social revolution. Then Sir B.N. Rao told that they are moral precepts for authorities. Then M.C. Setalvad, who was the former Attorney General of India, he told that they are instrument of instructions, useful beacon lights, so they are used for judicial review. Then they are dominating background for all the state action. Whatever state does, Dpsp is behind them. Then they amplify the preamble. Then other roles of this utility of Dpsp, they serve as domestic and foreign policy stability and supplement fundamental rights. Fundamental rights basically gives political rights, whereas Dpsp gives both social and economic rights. So they are supplementary. Then creates favorable atmosphere to enjoy fundamental rights. And opposition can control the ruling party by telling them to implement Dpsp. Then it is a crucial test for ruling party, how they are performing. Then it can also be used in the manifesto, political manifesto. Then if there is a conflict between Dpsp and fundamental rights, basically see, on one hand we have justiciability of fundamental rights and non-justiciability of Dpsp. On the other hand, we have moral obligation to implement Dpsp. So which one to select? So this was the question which came up in the subsequent Supreme Court cases. First one is the Champakam Dorai Rajan case versus State of Madras, 1951. In this case, Supreme Court told that fundamental rights are given primacy over Dpsp in case there is a conflict between those two. And it held that fundamental rights could be amended. So Parliament passed the first, 4th and 17th Constitutional Amendment Act to implement the directives. Now I'll give you a homework. You tell me what are these 1st, 4th and 17th Constitutional Amendment Act. Then Golaknath case, 1967, was the state of Punjab. Parliament said that cannot amend fundamental right. They are sacrosanct in nature. If you want to implement Dpsp, you cannot amend fundamental right. Now this is what Supreme Court told the Parliament, but then Parliament reacted by passing the 24th and 25th Constitutional Amendment Act in 1971. What does the 24th say? It gives the power, Parliament the power to abridge any fundamental right by constitutional amendment. Then 25th, the Constitutional Amendment Act says that it actually added a new article 31C. In 31C, there are two clauses. First clause tells that if there is any law made under 39B or 39C, and if that law violates 14, 19, 31, then that law will be held valid. Okay. Then another second clause told that and that law cannot be questioned in any court of law. But later in the Keshwanand Bharti case, 1973, this provision was made null, the second provision only. Whereas the first provision, it was held valid. Okay, then in 42nd Constitutional Amendment Act 1976 came about. this expanded the scope of this first provision. Basically, you can make a law for implementing any Dpsp, not only this Article 39B and C. You can implement any Dpsp and violate 14, 19, 31. Doesn't matter, it will be held valid. So basically, it gave primacy to Dpsp over fundamental rights. But this was held unconstitutional in the Minerva Mills case 1980. And Supreme Court told that, in this case, Supreme Court also told that Constitution is made from the bedrock of the balance between fundamental rights and Dpsp. This balance is considered as the basic structure. And then it reverted back to normal, that any law you make under Article 39 B and C, and if it violates 14 and 19, it will be held valid. Then 44th Constitutional Amendment Act 1978, Article 31, right to property. This was abolished. Then presently, fundamental rights is given more priority than Dpsp. Parliament can amend this fundamental right to implement Dpsp, but basic structure doctrine should not be destroyed. Now some directives outside Part 4. Basically, claims of SC and ST to services. If SC and ST want to get into services, they can get into. We can make provisions for that. State can make provisions to that, provided there is maintenance of efficiency in the administration. This is given in Article 335, Part 16. This thing came in prelims. One question came. This efficiency word is not defined. Remember that. Then instruction in mother tongue. Basically, state and local authorities can have to make facilities for providing primary education in mother tongue. This is given in Article 350A, Part 17. And development of Hindi language, Article 351, Part 17. It is the duty of the union over here. Here it is the duty of the state. Here it is, and local authorities. But here it is the duty of the union. So I think that's it.